Welcome. On behalf of the American Society of International Law, and as part of its first virtual annual meeting, I'm pleased to welcome you to this panel on the promise and prospects of the 2019 Hague Convention on Recognition and Enforcement of Foreign Judgments in Civil or Commercial Matters. As many of those listening know, the negotiations for this newest Hague Convention were concluded at the Hague Conference on Private International Law on July 2nd, 2019. My name is Peter Truboff. I'm Senior Counsel at Covington & Burling. I had the privilege of serving as the Society's president from 1990 to 1992, and also serving as a member of a number of U.S. delegations to the Hague Conference. We have a highly informed and thoughtful group of participants in this panel, so I will keep my introductory remarks brief. I should explain our panelists are in Kyoto, Melbourne, and Washington, so we had to pre-record this session so that everyone would be awake at the right time. Despite this logistical necessity, we promise to be lively and spontaneous so that you will enjoy hearing us on Friday, June 26th at 3:30 p.m. On behalf of myself and our panelists, I want to express our appreciation to the law firm of Curtis, Mallet, Prévost, Colt & Moselle LLP, which has kindly sponsored this panel. The firm's partner, Simon Boutefort, has agreed to co-chair the 2021 annual meeting, along with Christy Edwards at OSCE and Professor Darren Johnson at Howard Law School. So thank you, Curtis Mallet. We have promised that this panel will be a real discussion and not a series of speeches. To that end, I will introduce each panel and ask that she address my initial question concerning the 2019 convention. After each panelist has been introduced and responded to the initial questions, their answers should provide a solid foundation for our listeners. At this point, I and other panelists will follow up with additional questions and discussion to be clear. We received a few questions in advance from registrants, and we have asked our panelists to address them initially or up in the follow-up questions. And so with that brief outline of our procedure, I'm pleased to introduce our first panelist, Cara North. Cara North is a practitioner in Melbourne, Australia, with the Lippman Karas firm. She served previously as a legal consultant at the Hague Conference on Private International Law and at the 2019 Diplomatic Conference, and at the Special Commissions on the conference's Judgments Project. Cara, if I could ask you to start, could you please furnish us with an overview of the convention and its key provisions from the perspective of possible states parties and litigants?
Thanks, Peter. So first, I'd just like to say thank you very much to the American Society for International Law for inviting me to participate in this virtual conference. And I'd also like to say a big thank you to Peter for all his efforts in making arrangements for our virtual panel discussion. It's a great pleasure and a privilege to be speaking with you all. So just before delving into some of the key provisions in the convention, I think it's worth making two overarching points about the application of the convention. The first is that it deals only with indirect grounds of jurisdiction, as distinct from direct grounds of jurisdiction. So it's concerned with the grounds of jurisdiction. It's not concerned with the grounds of jurisdiction assumed by the court, which rendered the original judgment. Rather, the court, considering recognition and enforcement, looks to whether the judgment satisfies the indirect grounds of jurisdiction listed in Article 5 of the Convention and assesses whether the judgment is eligible for recognition and enforcement under the Convention. The second overarching point I wanted to make is that the Convention is designed to facilitate, not prohibit, the recognition and enforcement of foreign judgments. So it sets a base or a minimum standard for recognition and enforcement under the Convention. And if the prescribed criteria in the Convention are met, the judgment must be recognised and enforced. But if the criteria in the Convention are not met, it remains open to the state addressed, so the state before which recognition and enforcement is sought, to recognise and enforce the judgment under national law or under other intergovernmental arrangements. So then there's one exception to this general rule, which I'll touch on when I turn to the key provisions. But I think it's particularly important to make those overarching remarks because it gives context to the convention, and there are important points to bear in mind, bearing the history of the negotiation of the instruments and other regional and international instruments dealing with recognition and enforcement. So the convention is broken up into 4 chapters. The first chapter deals with scope and definition. The second chapter deals with core provisions. The third chapter deals with general clauses and certain declarations. And the fourth chapter deals with the final clauses, which concern important matters such as the process for ratification of the convention and the establishment of treaty relations. So turning to the key provisions, I'll just briefly mention a few in chapters 1 and 2. So Articles 1, 2, and 3 deal with the types of judgments to which the convention applies. Article 1 provides that it applies to civil or commercial matters. Article 2 provides exclusions from scope of matters that would otherwise be considered civil or commercial. And Article 3 provides important definitions, such as the definition of judgment, which provides for the recognition and enforcement of non-money judgments. And then Article 4 is the core provision in the convention, and it provides the central obligation under the convention. So that is that a judgment given by a court of one contracting state will be recognised and enforced in another contracting state in accordance with the provisions of the chapter. And then Article 5 turns to the categories of judgments that are eligible for recognition and enforcement. And this, as I mentioned before, is the indirect grounds of jurisdiction. So it provides an exhaustive list of these indirect grounds of jurisdiction. And there's about 13, but they fall into 3 sort of broad categories. The connection between the state of origin and the defendant. So, for example, habitual residence in the state of origin, jurisdiction based on consent. So, for example, express consent before the court in the course of proceedings, the court of origin, that is. And a connection between the claim and the state of origin. So, for example, the contractual filter. And then Article 6 of the Convention provides that one exclusive basis of jurisdiction concerning rights in rem and immovable property. And it provides that where a judgment ruled on rights in rem and immovable property, the judgment will be recognised and enforced under the Convention if and only if the state of origin is the state in which the property is situated. And this is the exception to that general rule I made reference to earlier about no prohibition under national law. And then finally is the last provision I'll mention is Article 7, which contains specific grounds on which recognition or enforcement may be refused. So not must be refused, it's a discretionary list. And there's a number of different provisions contained in Article 7, but they fall into 2 broad categories. Grounds based on the way in which the proceeding took place in the state of origin, for example, improper notice, or grounds based on the nature and the content of the judgment. So, for example, where the judgment is inconsistent with a judgment given by a court in the state in which enforcement is sought. So that's a brief overview of a few of the key provisions and some important points, I think, for the Convention.
Cara, that's very, very helpful, and we're going to pick up on a couple of the points that you've mentioned in our later discussion. So thank you. Our next panelist is Professor Yuko Nishitani. Professor Nishitani is a professor of international private and business law at Kyoto University Graduate School of Law. Yuko, would you kindly explain some of the key exclusions and adjustments under the Convention, and also the coordination of its provisions with arbitration and mediation?
Mm-hmm. Thank you very much, Peter. I'd like to sincerely thank you for organizing everything, and also the American Society of International Law for this kind and honorable invitation. So it's a great pleasure and honor for me to be a panelist today. As Cara has already explained, the 2019 Judgments Convention is a single convention that only deals with the recognition and enforcement of foreign judgments in civil and commercial matters. And it complements the 2005 Choice of Court Convention and seeks to attract as many states as possible. So this is why the 2019 Convention has a relatively limited scope and excludes matters where consensus could not be reached. So the scope issue is important to see how attractive and useful the convention will be in the future. And as for matters excluded from the scope, Article 2, Paragraph 1 of the Convention particularly excludes 4 important matters in my eyes. The first one is defamation and privacy. They are excluded due to constitutional concerns because these issues entail a tension between the individual right to reputation and privacy on the one hand, and freedom of speech and freedom of the press on the other. So because states draw different lines between these different fundamental rights, it was ultimately decided to exclude these matters from the Convention to prevent judgment circulation under the Convention. The second exclusion concerns activities of armed forces and law enforcement activities. These matters usually belong to state acts, and this is why they enjoy immunity, usually. However, comparatively speaking, states still use different notions between acta iure imperi, that are subject to immunity, and other acts iure gestioni that are excluded from immunity. That's why, in order to make sure that these important issues are excluded from the Convention, some explicit provisions are put in Article 2, Paragraph 1. The third one is to safeguard state interest in trade and economy. Intellectual property as a whole is excluded. So this deters the circulation of judgments deciding, for example, on patent infringement or copyright ownership to protect trade interests of the state. However, it's important to point out that contracts relating to IP rights fall within the scope of the Convention. So, for example, a judgment on a license contract which orders the payment of royalties is covered and enforced under the Convention. The fourth issue excluded from the scope is antitrust matters that deal with particularly administrative issues. However, the relevant provision in the Convention makes clear that certain important disputes concerning antitrust matters are included. So disputes between private parties resulting from anti-competitive agreement or concerted practice among competitors are included insofar as the conduct and the effects both occur in the state of origin. So if it concerns an extraterritorial application of antitrust law, this is not covered by the Convention. But if the conduct and effects take place in the same state, then this is covered by the Convention, so far as it deals with disputes between private parties. As for the coordination between litigation and arbitration and mediation, Article 2.3 excludes arbitration and related proceedings from the scope. This means particularly two things. So first, if the foreign court of origin renders a judgment on the merits, however, it breaches the arbitration agreement in the eyes of the recognizing state, then recognition can generally be refused. Second, if a foreign judgment is irreconcilable with an arbitral award, then the requested state may again refuse recognition. So these rules makes clear that arbitration is respected and the Convention does not intervene with arbitration. As for mediation, it is presupposed that the Convention does not touch upon mediation. Notably, however, Article 11 on judicial settlements covers agreements resulting from mediation, so far as this agreement has been approved by the court and is enforceable as a judgment in the state of origin. So these kind of judicial settlements are covered by the 2019 Hague Convention. And on the other hand, the 2018 Singapore Convention dealing with the enforcement of foreign mediation excludes these kind of judicial settlements from its scope to leave it to the Hague Convention. So by this way, there is a clear delineation between the two instruments. Thank you very much.
Yuko, that's very helpful in understanding what's within and what's without the convention. Our third panelist is Shubha Sastry. Shubha is an assistant legal advisor for private international law in the Office of the Legal Advisor at the State Department And Shubha, would you please provide an overview of what the convention potentially means for the United States and what might be its substantive impact for litigants in courts of the United States and for the courts when those litigants and the courts are addressing judgments that might be enforced abroad or judgments from abroad that might be enforced in the United States?
Sure. Thank you, Peter. Thank you very much for organizing this panel, and thank you to the American Society of International Law for holding the conference. I'm glad that under difficult circumstances, the conference was able to go forward virtually, and happy to participate in this panel with my distinguished panelists and to talk about the Judgments Convention, which is an important development in private international law. The Judgments Convention is certainly the culmination of many years of hard work by so many around the world. And in the United States, many of my predecessors, many other folks throughout the US government at the Department of Justice, and private sector and academic experts that we've worked with over the years. So it definitely reflects many years of very hard work. In terms of providing the US perspective, I wanted to put the convention in its proper context and highlight two background contextual points. The first is that we see the Judgments Convention as part of the broader private international law framework. And so, we don't view it kind of in isolation, but rather as part of that broader framework. And that the broader private international framework, of course, is, as a general matter, geared toward promoting commerce by harmonizing rules and providing greater predictability to commercial actors about the rules that will govern their interactions. And the Judgments Convention fits in that by setting some rules for how court judgments in a civil or commercial context will be received in the courts of another contracting state. And the Judgments Convention was, in fact, part of a broader proposal that the United States had put forward in 1992 that tackled a range of issues. So it tackled judgment recognition and also jurisdictional issues. And although that proposal as it was originally envisioned stalled, the Hague Conference has been tackling these issues in digestible pieces over time. So we had the Convention on Choice of Court Agreements, which of course established rules for private party agreements where they choose the forum for the resolution of their contractual disputes, and also provided for recognition and enforcement of the judgments from those forums. And the Judgments Convention of 2019 takes the judgments recognition piece, of course, and broadens it to court judgments more recently, or more generally, excuse me. And then, as was mentioned by Yuko, we also had the recent Singapore Convention on Mediation, which also fits within this sort of broader private international law framework that I was mentioning, all of which are aimed at promoting trade and investment through harmonized rules. So we see the Judgments Convention is fitting within that. And then the second sort of contextual point that I wanted to emphasize, and this was something that was, I think, alluded to in Peter's question, is that the United States is already quite forward-leaning in terms of recognizing and enforcing judgments from courts overseas, from foreign courts. But when litigants seek recognition and enforcement of judgments rendered by U.S. courts, that's when we tend to see more challenges. And so, relatively speaking, and so I think we view the convention as if a large number of states were to join, we view it as having the potential to start to correct that imbalance. And I think, we, like a lot of other Hague Conference member states, are in the early stages of taking a look at the convention and analyzing it. And we will be, engaging with our stakeholders to kind of think about what the most appropriate next steps are at this stage. Thanks.
Thank you very much. That's very good. And we'll explore a little bit further some of the questions of possible U.S. implementation in our discussion. Our final panelist is Ricarda Schanda. Ricarda is the legal advisor and head of legal affairs at the Embassy of Switzerland in Washington. And Ricarda, would you please outline the Swiss perspective on the 2019 convention in view of your nation's existing treaty relations, including those with the European Union, and explain in particular the issues that will be addressed as Switzerland decides whether the convention serves its interests?
Yes, thank you very much. With pleasure, and thank you very much for having me on this panel, Peter, and to Azel. I'm really excited to participate. From my side, just a quick disclaimer before I start. So my statements do not represent the Swiss official position because there is, in fact, no official Swiss position yet. There haven't been any consultations with stakeholders, and it would also not be up to the Federal Department of Foreign Affairs to be in the driver's seat, but the Federal Department of Justice. So whatever I say only reflects my own preliminary thoughts on the convention. Regarding the Swiss perspective, Switzerland is about 238 times smaller than the United States. There are 8.5 million people that live in Switzerland. My ambassador jokes that this equals about 2 blocks in New York City, or almost. Yet, despite being a small country, Switzerland is the 20th largest economy in the world. And we're also home to some of the biggest companies in the world, pharmaceuticals and food being our specialties. And while we are geographically at the heart of Europe, Switzerland is not part of the EU. However, and of course, we are integrated into the EU system by a whole web of bilateral agreements. And you can imagine that there is also a need to unify the rules on jurisdiction in civil and commercial matters within Europe too. So Switzerland therefore signed the Lugano Convention, as you mentioned, and the Lugano Convention provides a judgment recognition and enforcement regime parallel to the EU regime. And with the Lugano Convention, Swiss judgments and judgments of other EFTA states, so Norway and Iceland, are treated comparable to EU judgments within the EU. For us, the Lugano Convention would take precedence over the Hague Judgments Convention, and it already covers more than 60% of our combined foreign trade. Switzerland's number one trading partner is Germany, and the majority of our trade is within the EU. So therefore, a big part of our economic interests are already covered by this comprehensive judgments recognition and enforcement regime. Accordingly, the need to ratify this new convention is less urgent, especially also since there are other alternatives available, such as arbitration or choice of court agreements. But then again, looking at the Hague Judgments Convention, Switzerland will necessarily evaluate it with an eye on the EU position, because it is always advantageous to have a legal level playing field with our EU partners and competitors. But then again, at the same time, Switzerland will obviously make its own policy decisions based on our own priorities and options. And as far as I know, the EU is also still in the early stages of studying the convention. For us, when we look at reasons why the convention would serve our interest, it's important to know that one of the basic principles of civil procedure states that a judicial case should be heard by the judge at the place where the defendant resides. This dates back century. It actually goes back as far as Roman law, and it's also enshrined in our constitution. So Article 30 of the Swiss constitution says exactly that. It is the goal is to protect Swiss citizens and Swiss companies from frivolous lawsuits abroad. And when we ratified the Lugano Convention, which makes an exception to this principle, the Swiss people even had to amend the constitution to ratify the Lugano Convention. It was accepted at the time by Swiss stakeholders because in the 1990s, this led to a general economic integration within Europe. When we look at the Hague Judgments Convention, it's a limited it's limited to judgments, and it doesn't go along with greater market access. So it's a different consideration process. And another difference is that the Lugano Convention is limited to countries that already have similar legal principles. On the contrary, the Hague Judgment Convention doesn't have a common set of standards. It's an open convention that is open to any country that would like to join. And this obviously makes it more challenging because, as we know, judicial standards can vary from one country to the other. So Switzerland will carefully weigh whether we will introduce exceptions once again. Thank you very much.
Thank you very much, Ricardo. And I think I'd like to make one point and then have Cara pick up on the question of which countries do or don't join the convention, because that's an important provision in the convention. Each of the participants in this panel comes from a country whose delegations were extremely active in the negotiation of this convention. Schuber has reminded us of this, but we should also recall that the Swiss, the Australian, and the Japanese delegations were also extremely active. And so it's coincidental that we should have someone representing each of the countries from each of the countries that was so active. Kara, could you explain the difference between the current 2019 convention and the 1971 convention on recognition and enforcement of judgments that the Hague Conference worked out, and the provisions that deal with the issue that Ricardo has raised of who is your treaty partner, if I can put it that way?
Of course. So one of the key differences between the 1971 Convention on the Recognition and Enforcement of Foreign Judgments is that it made recognition and enforcement subject to bilateral agreements to be concluded between contracting states to that convention. So in other words, following accession to the convention, states had to take a positive step of entering into a separate agreement in order for the convention to have effect between those contracting states. And this was seen and has been written widely about as a rather complicated and cumbersome bilateralization mechanism, and has been widely noted as one of the main reasons why that convention hasn't been successful. And I think the members of the diplomatic session were very mindful of that when considering this issue of a mechanism to deal with how to enter into treaty relations. I've just mentioned a couple of other key differences between the 1971 convention and the 2019 convention, and then I'll come back to the provision in the Judgments Convention dealing with this issue. So one of the other key differences is that the 1971 convention was supplemented with an optional protocol that excluded a number of exorbitant grounds of jurisdiction. And so, in other words, like a bar on the recognition and enforcement of foreign judgments based on certain grounds. And by contrast, the Judgments Convention doesn't contain an optional protocol listing a number of prohibited grounds of jurisdiction. So that is a key difference, and that is something that's also been noted as one of the more complicated aspects of the 1971 convention. And one last point I'd add on the differences is that I think the Judgments Convention, the 2019 convention, is more international in character because of the growth of the membership of the Hague Conference, and because several members of the Hague Conference who historically may not have been as actively involved were very actively involved, as Peter's mentioned, during the negotiations, and had a much sort of stronger voice in the negotiations, which I think was reflected in the instrument. So it became less of a negotiation or a dialogue between the EU and the US, which it historically was, and now has a bit more, I think it reflects a bit more international interest, and it's obviously a lot more current because it was just concluded. So turning to the opt-out provision in Article 29 of the Judgments Convention, that provision really serves two purposes. The first is that it provides when the convention has effect between two contracting states. And the second is that it provides a limited opt-out provision to prevent the establishment of treaty relations between contracting states. So that provision contains 4 paragraphs. And I think it might be useful just to highlight what the paragraphs do to give a bit of context to this provision, and also in comparison to the 1971 convention. So the first paragraph provides that treaty relations will only be established between contracting states where neither of them has notified the depository to the contrary. And then it provides that where no notification is made, it gives a time frame for when the convention will enter into force between those states. The second paragraph is addressed to the contracting states, and it provides that they have 12 months to notify the depository that treaty relations will not be established with a joining state or an adhering state. And then the third paragraph is really addressed to the adhering state, and it provides that that state may notify the depository that it will not establish relations with one or more contracting states. And that notification is only possible at the time of adhering to the convention. So the rationale being that the adhering state is aware of the existing contracting states to the convention, and therefore should make that notification at that time. And then the final paragraph in that provision provides for a withdrawal of the notification, which can occur at any time. The rationale of that provision, I think it really operates as an important sort of safety net for some certain members of the Hague Conference. That's really the way it was perceived, and has just been it's just been mentioned. And it's also, I think, perceived as a necessary provision for a global convention in order to ensure wide acceptance and maximum reach of the convention, because there is that sort of safety net available. But I will just draw the distinction between the 1971 convention and this convention, really to just stress the point that this provision really stands apart from other mechanisms that are found like that in the 1971 convention, because it requires the adhering state or the contracting state to take an additional step in order to avoid entering into treaty relations with another contracting state, as opposed to taking an additional positive step to enter into the treaty relations with another contracting state, as is the case in the 1971 convention. So this additional step required to avoid the establishment of treaty relations with other contracting states will be a more sensitive and more carefully considered decision for diplomatic reasons, and it's less of an onerous way of joining the convention than that under the 71 convention.
Cara, that's very helpful, and I think Shuba's going to want to take you around the United States to explain that to the American bar and judiciary. Yuko, could you say a few words about how the convention addresses what we call parallel proceedings when the same dispute arises or has arisen in two different nations, in the courts of two different nations?
Yes, thank you very much for your question. Article 7, paragraph 2 of the convention deals with a situation where there are two proceedings going on between two member states and between the same parties on the same subject matter. And in this case, the requested state, so far as the requested state was first seized before the court of origin, and there is a close connection between the dispute and the requested state, then the requested state is allowed to postpone or refuse recognition and enforcement. And then if the situation changes, then a subsequent application for recognition and enforcement of the judgment is possible. But, excuse me, when there are, I think I may have been mistaken, but is it correct how I explained it?
I think that's right. It's not an easy provision. And needs careful thought, because we do get multi-jurisdictional disputes being heard. The main point is that the convention addresses this problem, tries to find a solution, a solution which isn't necessarily the one that we use in the United States, or where we tend to let the litigation go on and see who finishes first, so that there will be questions raised by practitioners and others as to whether it works in every situation. I don't think we need to go into the details more than that at this point. I'm inclined to move on, because I wanted to ask Shuba to say a little bit about the process by which the United States will go about deciding whether to sign this convention and submit it to the Senate for advice and consent, which may also have the question of implementation, both at the federal and state level.
Thanks, Peter. Yes, so this is, of course, something that we are starting to think about and look at. But as I mentioned in the outset, we're still very much in the preliminary stages of that process. We would need to consult with our stakeholders. We have an advisory committee process for doing that, and take into account, of course, analyze the text in light of current U.S. law, and think about what the modalities of implementation would be, of course. Just to say a little bit more about each of those things, I think one, to go back to a point I made earlier, Judgments is part of now a broader private international law picture that includes choice of court agreements. It includes the Singapore Convention. And so we're thinking of, I think it's prudent and appropriate to think about things sort of holistically at this stage. As many people, I think, are aware, in the period following the U.S. signature of the choice of court agreements, the United States pursued in-depth discussions with stakeholders about how implementation should be structured. And those discussions reached an impasse largely because of a divergence of views about how to resolve federalism issues. So in other words, what should be the relative role of state and federal law in implementing that agreement? And we will, as we go from here, of course, bear that history in mind and be informed by it. But I think it's also appropriate to think about this as a new time, a new opportunity to think about these issues with, we have a number of years have passed since the discussion surrounding the choice of court agreements. We have new blood, we have fresh eyes on the case. And now we also have a broader picture. We have additional instruments that sort of fills out the picture a little bit more. So I think we can see the conclusion or the adoption of judgments as presenting an opportunity, I think, one, to consider this broader picture, and two, to kind of think about fresh ideas about the full range of possible paths forward. So sort of not, informed by, but not sort of limited by our previous experience. In terms of what type of implementing legislation we expect to see, it's certainly too soon to say. There are, numerous questions I think that need to be answered. I think one of our takeaways from the experience of choice of court agreements should be that there is not one clear right answer. There are a number of different ways these issues can be tackled. And so I think everyone should be creative, thoughtful, and practical in developing what our options are. And we'll, of course, need to weigh a number of factors, I think, in terms of what implementing legislation will look like. I think there are questions about how we currently structure things and what the reasons are underlying that structure, but also, what is the mechanism that we have in place in any approach to implementation that ensures that we can, allows us to ensure compliance with treaty obligations. And so those are the kind of primary considerations I think we'll need to be thinking about. Thanks.
Shubha, thank you very much. It gives you, the people listening to this panel, some sense of how you will have your hands full over the next year or two trying to be part of the new blood that brings about thoughtful and creative ways of accomplishing this. Ricarda, everybody knows of the Swiss commitment to arbitration, and I would like to ask you to address kind of two questions. One is, does that mean the convention really isn't that important to you? And does it matter to Switzerland if the United States becomes a party to this convention?
Yeah, thank you very much. I mean, I think on the first question, the arbitration question, I can be quite brief because the efficiency of arbitration is certainly a very important reason why there is no pressing need for Switzerland to ratify the Judgments Convention. Of course, there are additional benefits to court proceedings compared to arbitration, appeal rights, etc. But there are also manifold disadvantages, and especially if, unlike in arbitration, the defendant was not able to choose the court. So it's a balance of interests. And Switzerland is an exporting country for arbitral awards, but not for court judgments. For example, Switzerland hasn't yet established an international commercial court. So having Swiss judgments circulated internationally is less important for court proceedings than for arbitration. This may change, of course, but at the time, at this moment, this is one of the factors that would play a role. And when you ask me if Switzerland would care if the United States becomes a party to the convention, I have to say yes. The US is Switzerland's second biggest trading partner. Switzerland is the 7th biggest investor in the US, and Swiss companies create 750,000 jobs in this country. And in terms of R&D, we're number 1. So ratification by the US would certainly raise awareness of the Judgments Convention in Switzerland and put it on the radar and on the agenda of our lawmakers. At the same time, there are a lot of differences between how Switzerland and the US deal with lawsuits in commercial settings, and these will obviously be taken into account as well. So, for instance, and as Shuba mentioned before, US judgments are harder to enforce abroad. I guess the US has what one might call a very plaintiff-friendly procedural system. There are lawyers' contingency fees, which mean a lower cost to entry for plaintiffs. Defendants often choose to settle because the cost of pretrial discovery are so high, and plaintiffs are not held responsible for the defendant's attorney fees, which is something that amazes me every time, because they're not considered damages. And when you look at Switzerland and many European countries, on the other hand, the plaintiff is required to pay securities against the likely costs for the defendant, and this automatically lowers the number of frivolous proceedings. Also, Switzerland and many European countries do not have pre-trial discovery proceedings, so the plaintiffs need to have all the evidence in place before they can start a lawsuit. And then there are also no punitive damages. This is all in order to prevent speculative lawsuits. And I guess the result is that in the US, civil proceedings are sometimes used as an economic weapon. Prime example is the patent troll lawsuits. Yet there, as was already pointed out, thanks to the negotiation skills of the US delegation, including Shuba, the Hague Judgment Convention does not apply to intellectual property. Nonetheless, there are similar types of lawsuits that tend to happen in plaintiff-friendly legal systems, and I assume that Switzerland and some other countries will not be eager to enforce some of them. So the way things stand right now, it's a matter of determining whether Switzerland would benefit from enforcing more foreign judgments, and at the moment, I would guess that it would be rather a price to pay and instead of a benefit to gain. But I mean, it all depends on how the convention will work out in practice. Thank you.
That's an interesting perspective. I want to finish the panel, and we're starting to come close on time and get the other panelists to think about a question here. The theme of this panel was the promise of the entire meeting is the promise of international law. So I want to finish up by asking each of the panelists, does the convention potentially fulfill the promise of international law? But before I turn to everyone on that question, Yuko, could you say a word about Japanese adherence to the convention? How do you think this will be thought about? Because it's not a subject we hear a lot about, and it would be interesting, given your expertise, to know what you think will be the initial reaction.
Mm-hmm. Thank you very much. I can give you only my personal opinion, so it does not represent the government's opinion. But first of all, our concern may be that we do not have exclusive jurisdictional ground for disputes over rights in rem in immovable property. So comparatively speaking, it's unusual jurisdiction ground, but if we should join the convention, then that will collide with Article 6 of the convention. However, if we think about that two Japanese parties living in Japan, but they have disputes over rights in rem in immovable property located abroad, our judgment would not circulate in general in foreign countries. In that respect, joining the convention does not change so much. And I rather think we gain a lot of benefits from the convention because among Asian countries, we do have difficulties of judgments enforcement because of reciprocity requirements. So between China and Japan, there is currently no judgments enforcement because we say against each other, we do not have reciprocity. The situation is similar with Thailand, Indonesia, Myanmar, Philippines, and Vietnam. So although Asia is coming up with the economic growth, judgments recognition and enforcement is hampered. So in that respect, joining the Hague Convention, the 2019 Convention, and also the 2005 Choice of Court Convention will be a reasonable way out to solve this problem. So I think
you've answered two questions at once, because in a sense you've shown how the convention could fulfill the promise of international law by creating a reciprocity regime that doesn't exist at the moment. You've made another point that I want to remind everybody. There are other provisions in this convention which we've not discussed that are going to have to get a very careful look. There is, for instance, provision on consumer protection and employee protection that are not in U.S. law and which will get a very careful look by the American business community. So there's much more to be said than we've been able to say in these few minutes. But with the remaining time that we have, and with Yuko having started us off so well on one of the promises of international law that the convention could satisfy, namely establishing a reciprocity regime, let me start with Kara and see how she feels about the theme of the meeting and whether this convention might fulfill the promise of international law.
Well, I think that the convention will fulfill the promise of international law. I think that looking at it from a litigant's perspective as opposed to from a state-based perspective, I think that the convention holds the promise of offering better access to justice to litigants around the world, which is a huge step in the right direction, and to offering litigants with more options. I mean, obviously, there are established regimes out there that work really effectively, in the form of arbitration and mediation and alternatives to dispute resolution. But I do think that giving parties more options and better access to justice is a positive step, and it fulfills the promise of international law.
That's a helpful way to look at it, and I've often in my writing emphasized the value of these conventions to what I call middle class litigants, not the big companies that my law firm or yours represents, but the people who have disputes that don't justify huge legal fees, but where they would like to know, will my judgment be enforced, and should I bring this case, or if I have a judgment, can I get it enforced? So the middle class litigant needs some focus here, and of course, Shuba and others carry the burden of trying to help them as well. Ricardo, what about you? You've told us why you might have a certain jaundiced or skeptical view of the convention, but where might it fulfill the promise of international law?
I think it can, and it probably will. And as you said, Switzerland has been really active at the Hague conference to get this convention off the ground as well. When we look at the Lugano Convention, it shows it's a great example on how the economies of countries get closer, how it does work with the enforcement of judgments. And so I think in a broader context, and if Switzerland is ready, then it might very well fly. But as I said, at the moment, Switzerland, we have a quite recognition-friendly private international law. There is the Lugano Convention. There is possibility of arbitration and choice of court agreements. So I guess the need for some individual state is rather low for the moment. But then again, things may change, and it will definitely help to wait and see how the convention will operate in practice in other countries, and who will ratify the convention. And I'm just really excited to keep monitoring this convention and to keeping an eye on the public sentiment in Switzerland as well. Thank you.
That's very helpful. Shuba, how about you? Without taking a position on where the United States is going to be on all this, how do you at least personally see the possible promise here?
Yeah, I think I definitely see the promise of international law with the Judgments Convention. One might look around the world and see challenges to multilateralism in numerous different ways. But I think what we see often from the Hague Conference, as well as actually the big private international organizations, is actually a pretty impressive amount of technical work and success in reaching results. And so I think that the Hague Judgments Convention fits in that picture. And so there's reason to be to see it as fulfilling the promise of international law. As I mentioned in one of my points, we also see it as because the U.S. already does sort of recognize and enforce judgments quite readily. We see this as, helping to, of course, remains to be seen whether how many states ratify it, but it has the potential, I think, to, correct the imbalance with respect to how U.S. judgments are received overseas. So I think it has promised in a number of ways. And I think Kara made a really valid point about the sort of increased access to justice that we may see if the convention is widely ratified. So I also feel that we've raised a number of open questions in the panel that remain to be resolved, but I think it'll be exciting to see how this moves forward in the next several years.
Thank you. That's very helpful. I might also add that each of us knows as privatists how much time and effort it takes to explain this convention to the business community, to judges who haven't had cases like this. There's a huge educative process here that we're going to have to go through. That's going to take some time and effort to take just the provision that Kara spoke about, the opt-out provision. That's pretty important if you get in front of the Senate and are asked whose judgments you're going to enforce and how it's going to work. Really, I personally believe is going to require some thoughtful thinking on the part of the Hague Conference, which I think can act as a kind of facilitator and mediator of that process, so you don't have countries blackballing each other. On the other hand, you do have issues of independent judiciaries that are going to come up if you were before the Senate of this country, and I expect it would come up elsewhere. So there's some very delicate political issues that are going to need to be resolved in the course of this, as well as some challenges of just explaining the convention to the bar and the judiciary. At this point, we have a couple of minutes left. Do any of you want to ask anyone else on the panel a question? Well, you're pretty agreeable. I want to thank each of you because you've each contributed enormously to an understanding of the convention. And while there, as we circulated among ourselves, a number of articles that have been written here, you have to read 20, 30 pages to get as much about the convention as we've been able to put together in this 1 hour. So I am extremely grateful to all of you for your participation. Particularly grateful to our friends in Asia who have stayed up late so that we could do this all together, and to Shubha, who has not spoken on this subject since she became assistant legal advisor, and to Ricardo, who has obviously consulted with her colleagues at home, and that too is very valuable. So thank you all for the time and effort you've put into this, and I hope that those who listen to the panel will carry on this discussion, and feel free to contact any of us to clarify or embellish what we've said here. With that, I think we can say thank you for participation.
Thank you, Peter.
Thank you very much.
Thank you very much. Thank you.